Hi, my name is Benjamin Berger, and I'm a professor at Osgoode Hall Law School and the York Research Chair in Pluralism and Public Law. I'm also one of the co-conveners of this workshop, and I come to you for the purposes of this primer video as a teacher and scholar of the law of evidence. The goal of this short primer is to help us open the field of evidence for our conversation by softening some of the traditional views of what the law of evidence is all about, and to offer another way of conceiving of it, one more conducive to thinking about the study of evidence as more central to public decision-making than it currently is. The conventional view of evidence law in common law jurisdictions, including in Canada, is of evidence law as essentially coextensive with the rules of exclusion. And so we focus on the rules of hearsay, or the rules of credibility, or the rules of character. These rules are thought to be the heart of evidence law. And knowing the law of evidence is essentially being adept with the use of these rules. Now, this view not only dominates academic treatments of the law of evidence, but unfortunately, the teaching of evidence in law schools and the view of evidence in the profession, including amongst advocates and decision makers. But this view creates a number of problems. The first is that it's naive from a comparative perspective. It fails to account for evidence law as a topic that reaches across jurisdictions, across legal traditions. You see, most of the world does not center its evidence principles on rules of exclusion. The continental or civilian tradition, which grounds the approach in most of the world, is based on a system of free proof overwhelmingly, with few rules of exclusion based on the quality or value of the evidence, and leaving matters of that value of the evidence and the risks of hearing certain kinds of evidence to principles of reasoning with and weighing that evidence. But secondly, this view, traditional view of the law of evidence, isn't descriptively accurate of even how the rules of evidence really influence common law settings. And this is true in two respects. First, the rules of evidence affect the thinking, the actions of actors like lawyers, like other state officials, throughout the flow of a legal process, even when they're not formally being applied. But secondly, in courts, even in that traditional setting, the amount of information reasoned with vastly exceeds the body of information assessed for exclusion. A third problem with this traditional or conventional view is that it focuses us overwhelmingly on courts and trials before courts. This is not where most hearings take place, nor is it where most justice is accessed. So it reads evidence law out of the dominant fora for accessing justice in Canada, and that seems intrinsically problematic. Fourth, and associated with this last point, it suggests that only those who are in the practice of excluding evidence ought to work to understand and reason with the principles of evidence law. These latter two features are very helpful in explaining why the conversation between administrative law and evidence law has been so thin historically, the thinness that we hope to address in part in this workshop. So what's an alternative? Well, we actually have an alternative already available to us in the corners of scholarship and thinking on evidence. And it's an alternative we are embracing for the purpose of this workshop. This way of thinking about evidence is captured by the so-called new evidence scholars. And these thinkers prefer to approach the law of evidence as a body of legal principles concerned more broadly with fair and just reasoning with information. Now, the result of reasoning might, in some settings, be exclusion, actually preventing a decision maker from considering that information. But that possible outcome does not define the core of the field. Rather, the field of evidence is overwhelmingly interested in good logical reasoning, inflected by values and principles of a fair and equitable justice system. Rules of evidence appear here and there, but thinking about how good logical reasoning can capture our values, our interests, our principles is really the heart of it. Put shortly, evidence is really about the just management of information through public decision-making processes. Now, we actually find precedent for this view in someone who's thought deeply informed both the common law and the civil law traditions, Jeremy Bentham, the 18th, 19th century philosopher. He said that the field of evidence is no other than the field of knowledge. Good knowing. That's what evidence law is really about. And this view led Bentham to what was called an antinomian view of evidence law, one without formal rules. Now, that's not quite where we went, but it's actually not far off from a realistic, attractive, modern view of the heart of the way evidence operates. Now, the great American evidence thinker, Thayer, described common law evidence in a way very much sympathetic to this view, describing it as follows: the law of evidence consists of a series of disparate exceptions to a principle of free proof. The subject is given coherence by the principle. Free proof involves the application of ordinary common sense, practical reasoning within the competence of most citizens. And so the law of evidence was about regulating, thinking through, capturing the best of this good logical reasoning. And we can find in the great scholar of evidence law, Wigmore, perhaps the best, most succinct articulation of this idea. For Wigmore, quote, "the logic of proof is anterior to the law of evidence. How we reason well about proving things is the backdrop and the precondition to the rules of evidence. It's the thing itself." The new evidence scholars seize on these ideas, and we ask you to play with them. Twining, a representative of this school of thought, urges us to return to thinking about evidence in a way that is compliant with this kind of alternative view, and he suggests that it focuses us on a different set of priorities when we're talking about what evidence law is all about. It focuses us on good reasoning in the specific context of legal arguments about justice, which are, therefore, animated by justice values, and which should apply to all aspects of our justice system where we care about sound decision-making. Now, though Twining argued specifically about the criminal justice system, my invitation to you is to use this frame to explore public decision-making at large. So when we turn our minds to burdens of proof, we can think about risks of decision-making and who should bear those risks, as we will discuss in our workshop. When we turn our minds to hearsay, we can think about the formal rules a little less and think more about what we need to feel comfortable about the reliability of information. When we turn our minds to character evidence, we think about the risks of bias, of stereotype, of substitution error, answering easier questions when faced with more difficult ones. And when we look at any evidence, we focus much more on ensuring that we are careful with questions of relevance and with inferential reasoning at all moments. What are the benefits of viewing evidence in this way? Well, put shortly, we can begin to see connections and then learn from varieties of legal traditions. We're much more realistic about how information is used in courts, but we can also more easily consider and work with decision-making contexts well beyond courts. Because of all of this, our management of information overall is more likely to consistently accord with the values of the field of law with which we're concerned. It's this way of thinking about evidence law that we're inviting you to explore in our time together, and I very much look forward to our conversations.